Okay, it is week 2, and welcome to Introduction to Criminal Law. And we are going to cover um, 2 chapters, or attempt to cover 2 chapters. We'll be on at least until 10 o'clock. I won't go beyond 10. So if I finish one chapter, I will finish that and then um, cut the tape from that particular point. I used to go on later, and it would go sometimes to 10:30 or 11, but that's too long for these lectures. So at any rate, make sure that you um, should have received the PowerPoints that I sent you already, uh, chapters 3 and 4 that we'll have this week for our second session. So let's go ahead and just get started here. Okay. And as you can see, there's information on the right side, which I won't go over: my name, my phone number, and everything, and how you can reach me. And then the additional information that we covered, the rubrics. Notice that this week, your written assignment, cruel and unusual punishment. It's all about the Eighth Amendment. We'll be talking about that a little bit tonight. This paper is 2 to 3 pages in length. Defines and discusses constitutional issues on the Eighth Amendment, and then you'll answer this question and then explain why and why not the execution of minors may be in a violation of David's constitutional rights. There is one particular case, and I'm not going to tell you what it is now. If you listen to the lecture, you'll get it. That's very important and critical about answering this third question. It has been resolved, and we're gonna discuss that tonight. That's why it's good to come to the live lectures, because you'll find something out firsthand. You'll find out later. So, but anyway, your APA requirements: lose 3 points if you don't, and then 1 point for no spelling or grammatical errors. So you want to make sure that you maximize your 20 points, and that's for week 2 this week. Notice as we scroll down that there is no project this week, and I am in the process of grading papers. I should have all grades in for week 1 by no later than Sunday. I'm going to attempt to have them by Saturday, but at any rate, it's quite a few papers to grade. And pay attention to my comments. Pay attention to my remarks that are in there, and you will discover how to correct them. The most common error generally is the APA issue, along with not having the proper length of paper. But anyway, there is no course project this week. There will be one more next week, and then you won't have another until week 8. So in the meantime, then, this week, written assignment, and then your discussion post, and we've discussed this already, and then a reminder about your lectures to take place every Tuesday, beginning tonight and go until 10. Next one will not be until week 4, and also your recordings here. So it tells you, if you click on this, that it'll take you right to the open house, which, by the way, I sent you, but you can refer to that throughout the quarter. Then there's one other one I want to bring to your attention. This is inbox grading system, which you get a chance to look at this. You will discover that I use this sparingly. I use this section more, and then I put in my comments to you guys about your grade. Very rarely do I edit your papers. Once in a while I will, because of the fact that most of you do pretty good with grammar and writing, but if there's something wrong, I'll let you know that. So this is a new, what they did was they changed from Crocodile to this new box, is called. And so it's pretty much the same, except there are things in there. And if you look at this video, you'll see what I'm talking about. Okay. So I'm going to get right down here to our week 2 announcement, and I'm trying to see why do I have 2 again. This one should have been gone by now. This is not supposed to be here. I deleted it last week. Suppose I'll have to delete it again. Give me 1 second, because that's not supposed to be there. I don't know why it's there. Going down. 2, 3, 4, 11, 2. Yeah, this is supposed to be gone. I deleted this. Delete it. So now it should be gone. Week 1, week 2. Okay. This should be gone too. I deleted this last week. Delete it again. Hold on 1 second here. Like I said, I don't know why these were in here. I'll do the rest of them later. At any rate, going back to the course homepage, still there. I don't know why it's not. Oh, I know why it's still there. Okay, now it's gone. All right. So anyway, this is our week 2 announcement for the week there. Module 2, Constitutional Issues and Elements of Crimes, Chapters 3 and 4 of Criminal Law and Procedure. And we'll discuss the activity briefly, the Constitution and Elements of Crime. Your initial posts due tonight, 11:59 p.m. Central Standard Time. Quite a few of you have jumped on it as of yesterday. Topic: strict liability crimes. Strict liability crimes. We'll talk a little bit about that tonight as well. And then your reply post will be due Saturday, 11:59 p.m. Central Standard. And then your written assignment, as I said, cruel and unusual punishment. I went over that a minute ago. And then, of course, your quiz. And again, I encourage you to do your quiz on Sunday at the end of the week. By that time, you will have gone over all the material, and you'll be familiar with what's on the quiz. And then I talk about let's start strong, let's finish strong, and you know why I say adversity is a springboard to success. You've seen my story or heard my story as I gave it to you last week. Okay, quickly as we move along here, let's look at the course calendar. Again, if you see a discrepancy in the announcement, go to the calendar. The calendar will give you the exact answer that you need, like this reading for this week, and then your initial post, your reply post, and then your written assignment, and then your quiz. So that discrepancy that you saw with the number 2 announcements, you'll notice that other one was for another course. Like I said, something weird has been going on here, and it's been showing up. So you go through the week, and by the 14th, you'll have this done. Then next week, you'll be pretty much no lecture, and then your next lecture will be the 23rd. That's when we'll be in week 4. Let's go to the module. Let's look at the assignments one more quick time. And it gives the facts and the Eighth Amendment. And then it says, deals with neither bail, excessive bail, nor fines, excessive fines, no cruel or unusual punishment. Notice that it's highlighted. That's telling you that that's the section of Article, the Eighth Amendment, rather, that we'll be focusing on. In a 2 to 3 page, I already told you what you had to do here. Okay, make sure you have a cover sheet, citations and references, Remember I said that. Make sure you run your papers through Grammarly, because I do check for Grammarly right away. Especially make sure you plagiarism part. Then your discussion posts. Okay. Very interesting idea, strict liability crimes, but it makes sense. And then of course your quiz at the end there. Okay. So now let's go back to the lesson content for this week. And we're going to discuss constitutional issues, elements of crimes, and how crimes are classified. And again, this gives you reading assignments. And always remember, when you're writing your papers, you must do some research. It's in here as well. And you will lose 2 points if you use just the textbook. Some student asked me, can I use a textbook? Yes, you can, but don't make that the biggest portion of your paper. I'm more interested in your research and your critical thinking. Okay? So you're going to go over these issues and take a look at these and learn about these. We're going to talk about this right off the bat in a few minutes. Judicial review, and then standards of judicial review, federal versus state law, which you were introduced to basically last week in terms of federal courts versus state courts. Then the Commerce Clause. The Commerce Clause, Article 1, Section 8 of the Constitution, we'll be talking about that. The First Amendment, and so make sure that you activate your audio so you can hear. If you can hear me, that means you've already activated it. Cruel and unusual punishment, that deals with the Eighth Amendment. Again, that has to do with your written assignment that you have this week. Strict liability, and it is a crime. Just for a minute, I'm just going to comment about this. Earlier under common law, it says that all the prosecution had to prove was that the person committed the act and had criminal intent. However, though, since that time, criminal intent, which meant there had to be a state of mind or mens rea. However, though, after that, many jurisdictions pass laws that don't require mens rea or criminal intent. So just the mere fact that one commits the act, these are known as strict liability. The name gives it away. You're strictly liable if you commit the offense, not whether you knew. Ignorance of the law is no excuse where that adage actually applies. And it gives example. Many states have passed legislation known as statutory rape. And in statutory rape, you should know that the age of the minor is something, I don't care how they looked, he or she, if it was a violation of what their statute says, you were guilty. Even if you were convinced that the person uh, was consensual or that you thought they were over the age of 18. And so it applies across the board here. And so we have that included today in our assignment about the driver's license issue that David has to face. And so there's some of you who believe that they're unconstitutional. The courts have said no. But there's a reason why strict liability offenses, most of them, you don't go, they're misdemeanors. Now, the difference between a felony and a misdemeanor is the sentence. If you commit an offense and the sentence is a year or less than a year, should I say, it is a misdemeanor. If it's a crime that you commit that takes you a year and above, it is a felony. Very simple idea. And most strict liability crimes are misdemeanors. Therefore, the sentence for incarceration is generally less. Generally, there are fines. Now, in this one that they give here in this scenario about statutory rape, it's generally not a fine. But with the license issue, or either someone trashing something, leaving garbage, their grass growing too long, or not satisfying the village requirements under the law, strict liability, you'll generally be a fine or something like that. So that's what I'm going to tell you about strict liability. Now, whether you say, oh, it sounds like due process is being deprived, not necessarily, because the onus is put upon the individual to exercise due care and not violating those laws. So now let's look at a little bit here about what's this parties to crime. I'm not going to talk about that. You'll go over and look at that. But I want to just take a minute to show you, I've mentioned this before, these little drag and drops. And so I'm not going to go over them a lot because of the fact that we will have them coming up every week, pretty much anyway. But a retroactive law recognizes an action that was legal at the time it was performed, or increases punishment for a criminal offense after it was committed. It's general intent, ex post facto, accessories before the fact, enumerated powers, specific intent, accessories, implied powers, accomplice principle. Anybody want to take a shot at which one they think is the right one? Which one? You can type it in. No takers? Okay. Edgar says ex post facto. Let's try and see if he's right. He's absolutely correct. And Kristen says it also. Yes, it means literally Latin. It means after the fact law. Just what the definition says here. Just what it says here. And so you can go over each of these and drag and drop and do them yourself. So I'm not going to do them with you today because we have so many to cover. All right. So now, with that being said, I'm going to get right into the lecture to cover as much as I possibly can. Make sure that looks like Jory is there. Make sure that make sure that you activate the audio. And you got to make sure you do that. You won't hear anything if you don't activate the audio. Okay, and then change your setting, Edgar, to everyone by doing this, taking it off of and putting it on everyone. Okay, when you put it on everyone, then they'll be able to see it. All right. So let's go ahead and let's get started. Um, this is chapter 3. As you have this, you also should have the outline of the chapter as well. I won't go over that because that's for your own help in terms of understanding the materials that you've covered and something that assists you in performing uh, better, I think, on the exam. Okay, I'm going to make this full screen for right now. Then you should be able, you should be able to see it a little better. Let's see if that's going to work. Okay, yeah, but it's not going to allow me to transfer it, change it. So I'm going to go back, make it a little bigger. Yeah, it's too small. Let's make it bigger. Okay, that's that. Okay, so we just have to go with that. All right, so let's get started. What is judicial review? Judicial review is what it says. It means that all laws, as you should know, are passed by the legislative branch, which is on the federal level, the House of Representatives and the United States Senate. And every state has the same kind of setup, House and Senate as well. The laws are passed and then they are passed on to the president in the case of the federal level and the governor in the case of the state level. And in those instances, it becomes law. However, all law is subject to the third section on our check and balance, the courts. And the courts operate under what we call judicial review. That is to make sure that the laws that are passed satisfy the constitutional requirements of our U.S. Constitution. And since the case 1803, it's Marbury, not Marburg. Marbury versus Madison, where the statement was made that it is the federal courts or the courts that determine or interpret the law, and it applies to all state and federal courts to determine whether something is constitutional on its face, which means per se, or if it's being applied unconstitutionally, which means on its face it appears to be constitutional, but how it's being applied to discriminate against a person in violation of the 14th Amendment for the states, or or the Fifth Amendment, or any of those constitutional amendments. So it is very simple, saying that the courts review the laws that are written. Okay. The legislature, we already talked about this, so I'm not going to talk about that. Legislatures pass the laws. They also have what we call enumerated powers in Congress. That is, that they can pass laws that go across state lines. And they use Article 1, Section 8, the Commerce Clause for that. We'll talk about that. And then they have certain implied powers. Now, there are criminal laws that generally are found in 18. It's found in 18 U.S.C.A. These are the criminal laws, usually United States Code. And the reason why it's annotated, A is for annotated, is the same way as when I tell you to do an annotated bibliography. It elaborates on the law itself and provides cases and issues that are decided by courts relating to that section of the law. And I said the Commerce Clause. When there is an issue that affects more than one state, Article 1, Section 8, allows the federal government to pass laws or enact criminal laws. For example, Congress cannot prohibit prostitution, um, but it is a crime to transport persons across state lines for immoral reasons. Now, here is something that you ought to know. And for many years, I thought, and then I did a little more research. Um, Prostitution is not legal in Vegas. It is not legal in Vegas. Hear me again. There are some people who thought it was, but that's not necessarily true. There are some issues that take place in Nevada, the state of Nevada, that allow certain things to take place, but it is not really legal. And it's not because of the Commerce Clause, it's because the states, each state decides those kinds of things. But on the other hand, what the federal government can do with the Commerce Clause is, and they passed a law called the White Slave Act, which means that if you take a person across state lines for immoral sexual activity, then you've violated a federal law because you've crossed the state lines. So there are many laws. The Patriot Act is one. The RICO Act, Racketeering Organized um, and Interstate Commerce Organization Act exists, which we'll be discussing later on in this course. So Congress has broad authority to enact criminal laws that go beyond the states in which we live in. Treason, we're not going to spend a lot of time about that. Betrayal of one's country. It's almost like historical. Most heinous crime under common law, often abused, and it was abused and has been abused in the 50s, the McCarthy era, it's called, where if you disagreed with the government, that you were considered to be treasonous. And so the U.S. Constitution sought to limit the power of the government to use treason as a tool to punish political dissenters, that is, people whose political views were different than what the country might be. That would be the same thing that would happen if you were in Russia or one of those places, that you would be punished by the government. But in our country, we don't. Now, somebody might ask, well, what about some of these Al-Qaeda and all those? They fit into another category because it's not just the political beliefs, it's the actions that go with that. And it is indicated that the goal of those organizations is to create terrorism. So therefore, they fit into a different category. But you're free to believe, like, for example, I have friends who were Black Panthers. I even remember many people, including yours truly, was at one time listed not as treasonous, but as an undesirable person because I participated in the civil rights laws. I demonstrated. And because I was a leader in demonstration, I was at one time in a file that the FBI had, and I was able to, under the Freedom of Information Act, get that and get that removed. And basically what it says is that I wasn't going along with the program. I wanted the country to stay, to change. I didn't want Jim Crow. I didn't want people to be discriminated against by using the laws that were on the books. I wanted people to be able to get married of different races, as the case of Loving versus Virginia, which we discussed. And there was a great movie that I ordered called Loving that dealt with that. But the point of the matter is that at one time, it was so broad that it was used to punish people for that. And there's a lot of legislators, Congress people. Dr. Martin Luther King Jr. was said to be a communist because he advocated demonstrations, but for social justice, if you were involved in those kind of things. So there's a whole lot of things that have changed since that time. Okay. It says a person can only be punished for treason if they acted to levy war against the U.S. or in adhering to the enemies of the United States. These two are historical, again, Bill of Attainders, a legislative act imposing a punishment that says you don't get a trial, and ex post facto laws, as we talked about, laws that are passed after the fact. Both are prohibited under the Constitution. These two cases, Lovett and Calder, verse did away with those way back then. But why are we discussing them? Because you need to know the history of how the law evolves, and that's what we spend some time going over here. Carmel versus Texas reversed the conviction of this Scott Carmel for sexual assault on his stepdaughter. At the time of the offense, the state of Texas had a law that said that a defendant could not be convicted merely based on the testimony of the victim unless she was under 14. Carmel, though, had been convicted under an amendment to an existing law. The amendment, not the law, was ruled to be ex post facto. So anything that, and it makes sense. Why should you do something that's legal and then they pass a law saying it's illegal and then you be prosecuted for doing it after that fact? No, that's not good. The Bill of Rights consists of the First Amendment, which we spent a lot of time talking about here: freedom of religion, speech, press, and assembly. The Second Amendment, hot potato, right to bear arms and keep arms. I spend very little on this. It's a little section in here, and why somebody is calling me now, I don't know. Okay, that is a former student calling me, and I'm in a lecture right now in a class that this former student used to be in, and he hears me, so he'll just call me back later. Okay. Yeah. Okay. He wasn't realizing what was going on, so I'll call him back later. Anyway, the Fifth Amendment is the right against self-incrimination. And then the Eighth Amendment, we already talked about cruel and unusual punishment, and the Ninth. And then there's the 10th, which we don't go over very much there. We covered that in a constitutional law class, not a constitution, yeah, constitutional law class. But these first, second, fifth, eighth, those are the main ones. We comment about the rights retained by people when we get to dealing with privacy and stuff like that. So hold on there. Application of Bill of Rights and federal laws. The 14th Amendment came about that applied the Bill of Rights, the ones I just showed you, to the states themselves. As you should know, when the Constitution was first written, the 14th Amendment didn't exist. And so as a result, later, to apply federal laws to the states, the 14th Amendment came about. So then you can violate the 14th Amendment right of a person and the due process clause of the Constitution to deal with proper procedures so that people have a right to hearings, the right to face accusers, to prepare responses to allegations or charges that are brought against them. In the case of Cantwell versus Connecticut, this is a case where the Supreme Court struck down a state law in Connecticut where Jehovah's Witnesses were passing their message out, and the law in that state said that they had to get approval for their activity. The Supreme Court said no, because this was a backdoor way of violating the First Amendment right of those individuals. So therefore, you can't use the law to deprive religious practices unless there's some danger involved, and I'll comment about that a little later, and you'll see what I'm talking about. But the point of the matter is that generally, as a rule, it's a violation of the Constitution in disguise, and the Supreme Court said, no, we're not going to stand for that, and it's a landmark case, Cantwell versus Connecticut. the First Amendment, freedom of speech, is not absolute. It is not all speech. Lewd, obscene, libelous, profane, insulting, or fighting speech is not protected by the First Amendment. If your statements create what we call a clear and present danger, that is, you are creating dangers to people, you're inciting people, you're going to find that it's not protected. Or imminent lawless action, you're doing something that is designed, again, to disrupt and create havoc and possibly cause injury to other people. I mean, physical injury. Then the First Amendment says no, you can't do that. Elaborate a little bit now here on that. Schenck versus United States, constitutional case that I studied when I was even in college, upheld this person's conviction, saying that it does create a clear and present danger. What this person did was they mailed leaflets attacking American participation in World War. Now, here's the point. Things are different now because of the way we apply the laws now. But back then, during that war, I think it was World War I, but the point of the matter is that the laws have changed in applying. Clear and present danger doesn't operate as much anymore because we have statutes to take care of that, like the Patriot Act and other acts of that nature. But anyway, it was not protected because at that time, the activities of passing out these leaflets created morale problems with the military. We don't have that anymore. People protested the Vietnam War. All the wars, people have a right to protest in this country now. So it's a lot different than it was then. Hess versus Indiana. Pay attention to why this is considered imminent or not considered imminent lawless action. Supreme Court reversed the conviction of Hess because the speech he gave did not constitute imminent lawless action. So the state of Indiana said he was convicted for yelling, "We'll take the effing road street later," during an anti-war demonstration. He just yelled it out. He wasn't talking to anybody. He just yelled it out. So the court said, no, it wasn't directed towards a certain group or individuals. He was just expressing his belief. Therefore, it wasn't imminent lawless action. Remember, think about it. If you're starting to talk directly to somebody, then you start to head closer to imminent lawless action. But just expressing an expletive during an anti-war demonstration was not adequate enough to fall under imminent lawless action. Therefore, it was protected under the Constitution, First Amendment. Then we get to symbolic speech. Freedom of expression, broad concept that we have, embracing speech, books, performances, demonstrations. When I was coming up, there was a play called Hair that came out. There are plays that are out, Hamilton I haven't seen, but the point of the matter is that there's a combination of speech and performances that take place. There are other plays and books and demonstrations where people are able to say that they're against something. Symbolic speech includes using symbols such as, for example, armbands, badges you've seen in law enforcement. They put a little black thing over it when an officer is killed. Or you'll have some others. Some others include flag burning. Now, listen to me. Burning of the American flag is protected by the First Amendment. And it means you can burn a flag. But the problem is it better be your flag, not somebody else's flag. When you get into flag burning, it may disgust people. Just like, for example, the thing that Colin Kaepernick did when I was a kid. There were 3 people on in the Olympics. Two were black, and they held up their hands to salute Black Power. And Cheney was one. I can't think of the name of the other two, but you would see it. I think it happened in California, and that was a symbol of expression because of some protesting activities that were taking place. There are organizations that are out to conduct protests. When I was in law school, we, as students of Black American Law Student Association, we marched in D.C. against a Supreme Court case, and we didn't agree with that Supreme Court case, and so we marched, and that again was part of the reason why I ended up in a file. They got it all straightened out. But the point of the matter is that people march for all kind of reasons, and the law changes because of that. For example, people protested people getting married of different sexes, and as a result of that, their protests, their marches, ended up reaching the point where the courts got cases that challenged it, and you know what happened. So the point of the matter is for our country, you have an expression in terms of that, and that falls under the First Amendment. And you may not like it, but it's, I don't agree with everything that people march about either. So public speech that threatens the public peace can be punished. I talked about Cantwell versus Connecticut is protected. But if there's fighting words involved, then it's a problem. If it's hate speech, obscenity, or profanity. Now, again, remember earlier that Hess case, the profanity was not directed at an individual or organization, those kind of things when you get into that. I would even go as far as saying I would defend through the American Civil Liberties Union, they would, and it's ironic because the people that their clients can't stand them when they go to court to allow the Nazis and the Ku Klux Klan to march. The reason why is we have an adage in our country that we talk about as constitutional people, and my degree was in political science, that if we stop them, next it'll be us. So the point of the matter is we allow people under certain parameters and rules to express their positions. Okay. Texas versus Johnson, where Gregory Johnson was convicted of flag burning. He had burned the flag outside the Republican National Convention in '84 to convey an unpopular message. The court said he wasn't convicted for the flag burning, but the message he was conveying. So his message is protected under the First Amendment. So it is not a flag burning case. Some people use it for it, but it is not. You have to understand a lot of times, that's one of the things about being a lawyer that I try to get people to understand, is that you have to understand what the goal and purpose of the case that is ruled on by the court. What is the precedent? What is the issue that they're addressing? They might mention other issues, and then some people try to apply that as the law, but that is not true. And so in this case, you get the point of what I'm talking about. Flag burning was already resolved. Virginia versus Black. The Supreme Court held that states can punish an individual for burning a cross. Because once again, we get back to the point that I talked about earlier, it's intended to intimidate people. And also, this individual was creating a dangerous situation. So Black was a Ku Klux Klan member and burned a cross during a rally. And so, yeah, we had a justice that was a member of the Klan at one time. And I think no, it's not the same person, because this person, I think his name was Hugo Black. I know his last name was Black. I'm almost sure it was. justice of the Supreme Court. If you go back in history, you'll find people like that. There's other legislators that are currently even now legislators that were Klansmen, and all those different kinds of things. But anyway, the point of the matter is that you could punish this individual because they were intending to intimidate people. The free exercise of the First Amendment, and then we get into the right to peaceful assembly. Government may impose times and places for control purposes and also for protection of those individuals. You better believe that if the Klan is going to march or the Nazis are going to march in an area, we have a town in Chicago area called Skokie, and there's a lot of people of Jewish descent that live there. And so their position, especially with the Nazis. And so they allowed it to march, but they have to provide protection for them because for obvious reasons. So peaceful assembly is allowed in public places. Freedom of religion, exercise of religion. Exception, and I already said this earlier, the government can prohibit religious practices that threaten public health and safety. For example, the Tennessee court upheld the validity of a statute making the crime to handle poisonous snakes. This religious sect says we handle poisonous snakes as part of our religion. They said not in our state because it is a danger to health and safety. So in that instance, then health and safety, excuse me, will rule out your religious protections. Refusal to allow medical treatment for a child. Parents can refuse treatment for themselves on religious basis or any other basis, but not for their children. Not legal. Edwards versus South Carolina is a basic Supreme Court case in '63 that, and this was during an era when a lot of marches were taking place. The Civil Rights Act of '64 hadn't come yet. The Supreme Court upheld the right of peaceful assembly, where some black students participated in a peaceful civil rights demonstration. They were convicted for breach of peace, and the court says, "Nah, you're not violating their peaceful assembly, protected under the First Amendment," and that's what people would use. And notice where it was. It was in South Carolina, and areas of the South, it happened a lot. It happened not as much in the North, but in the South, in areas where change that should have taken place after the Civil War, but it did not. Wisconsin versus Yoder is kind of like a moot law now. When I say moot, it for other reasons it really doesn't apply. In which the Supreme Court required or said that for a state in which Wisconsin required compulsory attendance for the Amish, they said no, this is part of our religious beliefs that we separate ourselves. And if you do any studying of the Amish, and I don't know if that's changed, but they didn't even use electricity and things of that nature during the time. So as a result, the court says no, we can't they can keep their own kids. But you and I both know now that there's this homeschooling requirement that that exists, that people can homeschool their kids. We have one of our kids, for example, he's going to be 18 this year. Glory to God, he'll be 18. He is homeschooled and been homeschooled for several years. But our other kids, they don't. They go to school. They've graduated. My son, 22, and other daughter, she's going to graduate this year as well. Their birthdays kind of overlap a little bit, so therefore they're in the same grade. But the point of the matter is that one is at home, one's at school, and then our baby, of course, she's in school all the time as well. So the bottom line is that you can keep your kids at home, but you still need to have an organized program that the state can require that you provide proof that you're actually not just keeping them home. This is the one of the peyote cases. This is one of the cases I remember when I was in law school, in which the Supreme Court rejected the claim that the ritualistic use of peyote. Now, peyote is a hallucinogen. It's a mind-altering drug, and it was used by Native Americans in their ceremonies. Well, the court said that religious beliefs do not excuse people from complying with neutral laws that apply to everyone. Therefore, you couldn't use the peyote. Now, there is something that's happening, and this is because of what's taking place. As you know already, as of the 1st of January, many more states joined, states like Colorado and some other states, I think Massachusetts, and that Illinois is right there on the brink of legalizing marijuana, not just for medical purposes, but for recreational purposes. And so, anyway, the point of the matter is that you should be aware, though, that's the states acting, but the federal government still takes the position that it violates the law. So there's a clash here. It's going to have to be resolved at some point, but be aware of the fact that that's taking place. And so there was a church that was organized in Indiana, and it's called the Cannabis Church. And if you can Google it, the Cannabis Church of Indiana, you'll find that they actually have a church, and the people were able to, justify using cannabis in their services. The only thing is that Indiana is still illegal. So therefore, be aware, even though those people could worship with that if they are then leaving there and they're under the influence or even in possession of some, they can still be incarcerated. So it's a quagmire. It's still confusing. There are thoughts from both sides about medical marijuana. I mean, about not medical, but about recreational use of marijuana. There are things that they say, well, it takes it out of the criminal action. Well, not really. It always will be there. But the point of the matter is that the movement is happening. It's already moving toward the level of being removed from Schedule 1. It's still there, though, because the federal government is resisting. So we'll just see what's happening. I heard a person say the other day, they think that some of the legislators are using it already because of some of the laws that they are allowed to be passing, and that some of our higher government officials, I'm not naming any, but you use your own speculation, may be doing something drug-wise, because some of this stuff that they're coming out with now is like, what? You're seeing gifts on and everybody know what GIF gifts are on Facebook, where people are looking like, huh? What? So some of the stuff's happening. But anyway, that's a little editorial comment. All right, Professor Wright, let's move on. Thank you very much, sir. Okay, the Church of, I learned how to say it. Lukami Babalu Aye Inc., City of Hialeah. You should have seen me the first time I said it. I just butchered it. It's like Chevy Chase going. But anyway, in this particular case, the Supreme Court upheld the right of the church to make animal sacrifices as part of their religious ceremonies. Now, that might irritate some people, but the city of Hialeah had a law that said that it is illegal to unnecessarily kill, torture, torment, mutilate an animal in a public or private ritual or ceremony, not for the purpose of food. And so the court said this ordinance is unconstitutional because it violates the right of practice of religion. And so I'm going to ask you, because I already know the answer. Why is it, do you think, that the court ruled in this position? Now, I know there are animal rights people and on in these classes. I know there are animal rights people present, but do you have an idea about why, what justification, and if you go back and read the case, you'll find it, for why they ruled in favor of allowing the sacrifice of animals during their religious practices. Anybody want to type it in? Type it in. I'll give you a minute or so to see if this is like Jeopardy. If you can type in why you think it is, it can be a short answer. And again, if you type Edgar, make it public instead of make it to everyone instead of private. Anybody else? Any ideas? Okay, because animals don't have a Bill of Rights. No, that's not it. There's another reason that the courts don't want to get caught up in a quagmire. Remember, they were using it as animal sacrifices in rituals in their church. So, what is it you think the courts didn't want to get caught up in? That was a good guess, though. Anybody else? Okay. 5, 4, 3, 2, 1. I'm going to type in the answer. There it is, the Bible. In the Bible, in the Old Testament, animal sacrifices were part of the beliefs. And so people in the church are still carrying on what was in the Old Testament of the Bible. And the Supreme Court won't touch that issue. It's too hot because it would cut at the core of religious practices, and so that's the essence of it. And it makes sense. You may not agree with it. Remember, as I explained to people, the law is not whether you agree with it. The law is the law, and it's subject to change if people challenge it and bring good enough reasons to justify the laws being changed through the proper channels. So anyway, that's the answer to that question. So it's a straight up constitutional issue. It would infringe upon the fundamental, foundational First Amendment right to religion. Second Amendment, moving right along, the right to bear arms. Again, I don't spend a lot of time. The whole argument is whether or not there's people who believe that you have a right to keep arms or you don't have. And the whole argument goes between what it says in the U.S. Constitution, it talks about the militia and things of that nature, and who is the militia and who's the militia for today, and those kinds of things. And it goes on and on and on. But there is a conflict going on for gun control. Many states give wide latitude to local organizations. The state courts and including the federal courts always defer to the local organizations. However, if the local organization, like Chicago, for example, had one, they said no, it affected the Second Amendment, and it's how the courts interpret the Second Amendment that determines this. And I say this to you, and I mean what I say, and I go into it in more detail in the constitutional law class, where there's 1 week that all I spend time talking about is the Second Amendment. I'll just go to the point of saying that the legislator is tied up and controlled by a most powerful lobbying organization, the NRA, National Rifle Association, and so it goes very high up in terms of being able to control. It's really more about dollars and cents and gun manufacturers and things like that. But anyway, that's underpinning of what's happening here. So in the meantime, the Second Amendment is used to justify guns. The United States Supreme Court held that the District of Columbia ban is unconstitutional. That's what I said earlier. Heller applied for private use and was denied by the Federal Judicial Center, which cited the strict gun control ordinances district, and the courts strike them down. They strike down those almost every time. There are some exceptions. For example, when we get into the Brady Act, the Brady Act came about because former President Ronald Reagan was shot at. He wasn't hit because there's a Terrence McCarthy, who was the chief of police in a town near where we are now called Orland Park, and he was a CIA. He was a not CIA. He was a Secret Service agent, and he took the bullet for the president. But in the meantime, Jim Brady, who was a press secretary, got shot in the head by this guy John Hinckley, who just recently, by the way, they had an issue about him, and I think he got out. I think, but anyway, he passed away. Jim Brady stayed paralyzed and then passed away, and it established the requirement of background checks, which now is under attack again at the federal level. So, and there's a whole lot of issues concerning that. That's going to go on and on and on. And then, okay, hold on a second. I think I went back too far. Okay, I want to go to 26. Why don't we go to 26? Thank you. The doctrine of vagueness and overbreadth. What does it mean, that? It means very simply that laws can't be vague or overbroad. So no person shall be deprived of life, liberty, or property without due process of law. That means you have a fair hearing, opportunity to defend yourself, provide evidence, and those kinds of things. And then the vagueness doctrine limits the discretion of police and prosecutors to the point that the law can't be vague, so that you're not really clear on what it means. I'll elaborate on that in just a moment or so. Or overbroad. Prohibits laws that are written so broadly that they actually have the effect of potentially infringed upon the First Amendment right. Let's delve into that. In the Coates case versus the city of Cincinnati, the Supreme Court held an ordinance unconstitutional that said that it is a crime for 3 or more persons to assemble on any sidewalk and there conduct themselves in a manner annoying. Listen to this: annoying to persons passing by. Now, when you read this carefully and you get to this word annoying, annoying is a relative term. And so therefore it is hard for an individual. What annoys one person might not annoy another person, for example. And a person is not on notice about what type of activity is annoying. So if 3 or more persons assemble on the sidewalks, that means probably they didn't have exception for bus stops and things like that. But if you ever, when I went to high school, we used to be at the corner of a bus stop. Man, it'd be like 40, 50 of us trying to get on a bus, you know, and to get home. We had public transportation in Chicago. Some of you guys don't know what that's like, and my kids today don't know what it's like. But at any rate, the point of the matter is that it's annoying to some people. So the court said, no, that's vague, because it doesn't, and overly broad, because men of average intelligence have to guess at what it's meaning, and it makes sense. That's what I mean when I say that. We have a freedom from self-incrimination. You already know that there's Miranda rights that say you have the right to remain silent. Anything you say can will be used against you. You have a right to an attorney, and the rest of the rights that go with it. But the point of the matter is that you, my wife and I were looking at, they were looking at something the other day, and I was doing some work on the computer, and they said the police said they couldn't question them anymore because the person said that they wanted an attorney. I said yes, they were in custody because of the Miranda warnings. So you can't be forced to testify against yourself or give information against yourself. You don't have to testify in trial. As a defense attorney, many times I had instances and good justifiable reasons why I didn't call my clients to testify because that would create problems for them. They had a right to remain silent. And it limits the degree which legislation can write statutes that require persons to report information to the government that can place them in jeopardy, such as this one right here. This is one of my favorite examples. Leary. Timothy Leary was known as the drug doctor. Timothy Leary was convicted of violating the Marijuana Tax Act because everybody knew of his distribution and use of marijuana. But the Marijuana Tax Act required that Leary identify himself as a criminal by saying that he distributed or had marijuana. And since marijuana was unlawful at that time, he would be incriminating himself. So the court said, no, that law is no good. We can't use that as a violation. So as a result, you can't have a law on the books like that. I remember this well, 69, that was the year I graduated from high school, and I do remember this whole incident. Prohibition against cruel and unusual punishment. The Eighth Amendment, here we go, guys, applies to both procedural and substance laws, which means that how the process operates and the substance of the law itself often applies to challenges to the death penalty. Crime can also be employed to limit the definitions of crimes, such as Rasmussen versus California. The court struck down a law that made it a crime to be addicted to narcotics, because then what you were doing, you'd be dealing with the status of an individual, and a person should not be convicted or punished because of their status. So now here we go. The death penalty for juveniles. I told you, I promised. In the court, Roper versus Simons. And the case Roper versus Simons is a case that actually resolved the whole issue of the Supreme Court and the death penalty for minors. And while it doesn't provide it for you here, Roper versus Simmons is 543 U.S. 551, and the proper way to cite it is this way, 2005. That is the case. That is this case, that the execution of juvenile offenders constitutes cruel and unusual punishment. So we do not give the death penalty to juveniles. Okay, I had a young man I represented, one of my toughest cases at the end, who committed a heinous crime, and he didn't qualify for the death penalty because he was 17 when he committed the offense. He was 18 at the time of sentencing, but it was based on the time of the offense, and he didn't receive the death penalty. Well, in Illinois, this was before 2005, Illinois did not execute juveniles. And here's the issue that happened before Roper, is that some states said yes, some states says no, but the Supreme Court says we can't do it, and now is the law of the land. Scalia and Thomas, Justice Scalia, who's passed away, and Thomas, uh, uh, not one of my favorite Justice Clarence, uh, dissented from this decision, argued that the court should not legislate from the bench, and they felt like they were legislating from the bench as opposed to providing a constitutional issue. So anyway, that's a whole nother discussion. But the law of the land is clear, and it is settled. We do not execute juveniles, okay? The right of privacy, we get into the 10th Amendment, the Ninth Amendment rather, the sphere of intimate personal conduct, which we get into what happens in your bedroom, what happens in privacy between consenting adults, and it says that the enumeration of the Constitution shall not be construed to deny or disparage rights retained by the people, that is, of their right to privacy. The Griswold case has nothing to do with Clark Griswold, Jeffrey Chase. It is a famous case that is right here. Griswold versus Connecticut, in which the Supreme Court struck down birth control laws, saying that it violated the constitutional guarantee of marital privacy. So the birth control laws could not be used. Estelle Griswold was convicted for aiding and abetting persons in using contraceptive devices. So now this was dealing with marital. Now, later on, the next case comes up. Eisenstadt versus Baird extended the ruling of Griswold to unmarried persons. So it was the same thing. So as a result of both of those cases, it is well settled that we don't interfere in those kinds of things. And then we get to the abortion issue, which I won't spend a lot of time on. It's under attack right now. It's basically pro-life versus pro-choice, and seeks to protect those individuals. And again, I'm not going to spend a lot of time there. Roe v. Wade, that's the landmark case that, as you know, that is still in existence now, but you know it is subject to attack, and we don't know what the Supreme Court's going to do if a case comes up for abortion, but this was in 1973, okay? Pro-choice versus pro-life, and so we're not going to go over that. What is life and when does it happen? And then we already talked about Griswold, Roe v. Wade, and so forth. And then last part, provided the prerequisites for gay, lesbian, and bisexual activist movement, which resulted, it was not until 2003 that the Supreme Court recognized the privacy rights in Lawrence versus Texas for gay, lesbian, and bisexual people. But now you know what the United States Supreme Court has done in terms of the law. That was this past 2 years ago, I believe it was now. Okay, Lawrence versus Texas. Supreme Court held that the government may not criminalize adult sexual conduct. So there we go there. That's the case I was talking about a minute ago. The right to die is a medical decision under certain circumstances. There's a whole debate about the 14th Amendment, Equal Protection Clause, and whether or not individuals should have a right to make that decision. Equal protection of the laws applies to all people. Due process of law to all people. You have a right to hearings and so forth. And then these are the famous cases. Loving versus Virginia, I alluded to that early. Here it is. Yeah, in this case, it's 67, and it's very interesting. It was in 1967, when I was 17, that this came about. Supreme Court held that a state cannot restrict the marriage of people between race. At that time, the state of Virginia, once again, notice what I said earlier about the southern states, convicted the Lovings because they were different. They were a different race, and they were convicted for violating the state law, and it ultimately ended up going to the United States Supreme Court. And there was a famous case, Loving versus Virginia, which resulted in a movie. I recommend that movie. You'll enjoy it. I did. But it is very interesting what happened to tell somebody that you could not fall in love with someone of a different race and marry them because it was a violation of the law. Ridiculous. Judicial review, we already talked about that. There are three tests that are involved. There's a rational basis test, which says the judicial requirement that legislation must be related to a legitimate government objective. Then there's the strict scrutiny standard applies to First Amendment issues, to fundamental rights, in which the courts must establish, this is probably tough. It is one of the toughest decisions. And then the government compelling interest prove that the government interest is strong enough to override the fundamental right. That results in things like the Patriot Act and some of the other acts that exist. But these are the three tests that we studied in detail when I was in college and in law school. But these are what courts still use today, depending on what kind of issue is before the court. States, constitutions, the highest court of each state possesses the authority to have its own state. It was not until 1969 in Illinois that we had the Illinois Constitution, and many states operate on the basis of independence in terms of that. Okay, it's about 9:47, and I'm going to go through as much of this as I can in the next 15 minutes or so, take maybe a couple minutes over. The elements of crimes and parties to crimes. If you have questions, just type them in. Elements of a crime. Actus reus. That means that the act is wrongful in itself. Mens rea means criminal intent. So, prosecutors must prove either commission of an unlawful act or admission of an act. That means you didn't do something you're supposed to do, such as not filing your taxes and things like that. Strict liability, we already talked about that. Felonies and misdemeanors, I told you the difference between the two of those. Actus reus, the act of the crime, of the criminal when they do something. Person must willfully commit an act, such as robbery. Intentionally failing to act when the law requires a person to act. Negligence or failure to provide medical treatment, that can fall under that actus reus itself. So basically, the act of the person who's charged with the crime is actus reus. Possession as a criminal act. Possession can be a wrongful act, such as carrying a concealed weapon, unless you don't have a carry concealed, or you're law enforcement, or you have legal protection for carrying weapons. Possession of illegal drugs. Actual possession is where you have immediate control over something. Constructive possession, the power and intention to control something either directly or through another. People in a car should realize that if something is found in your car and you're the driver, regardless of whether you're the owner or not, you're going to be the one that's held responsible for what happens in that car, even if it's with a passenger. Generally, there are exceptions. Status, I already talked about that. We don't prosecute people for status. But public intoxication is different, because then you're not alcoholic, but now you have done something that affects others. U.S. Supreme Court struck down a California law that made it a crime to be addicted to narcotics. We talked about that earlier, that Robinson case. The Supreme Court upheld a law making it a crime to be in a public place while intoxicated. So, again, that was what I was talking about a few minutes ago. That's not status. Robinson versus California. implemented a new statute that made it a misdemeanor to be addicted to narcotics. The Supreme Court struck it down as a violation of the 8th Amendment and the 14th Amendment as applied to the state of California. Stated that the new statute was cruel and unusual punishment. They compared it to punishing a person for being an addict. It's like saying a person can also then be punished for having a common cold. So that's what we talked about a few minutes ago when I said status. Powell versus Texas. The Supreme Court upheld the conviction of Powell for public intoxication. And he was a chronic alcoholic, which that wasn't a reason, and argued that it was cruel and unusual punishment to be convicted for being a chronic alcoholic. The court says no, through Justice Thurgood Marshall, that Powell was not being punished for being an alcoholic, but for being intoxicated. Two different things. You can be not an alcoholic and be intoxicated. So, mens rea, the intent, the exception is strict liability crimes, which don't require mens rea. And mens rea means crime of the mind. Crime of the mind. Prosecution must prove criminal intent, but not necessarily a motive. A motive does not have to be proven, but a motive is good because it gives ideas about why a person might have done something. Concurrence of act and intent can be simultaneously, but not necessary. So with mens rea, with murder, robbery, and theft, I didn't intend on stealing it. Well, unless you have a defense, like for example, you didn't steal it, but you took it accidentally, but then you realized it was not yours, then you kept it. Then your mens rea kicked in. Whoops. Mens rea watered down because of strict liability crimes, and there's still arguments that makes it easier to be prosecuted. But remember one thing is that most of these are offenses that are not major offenses. General intent, willfully and unlawfully. That means you did it absolutely on purpose. Specific intent, the mental purpose to accomplish a crime. You had that proper mental ability to not do it. And willfully and with intent to injure a person, you do it on purpose. Specific intent statutes define criminal conduct in which the defendant must harbor a specific intent to accomplish a prohibited result. For example, taking a person's vehicle and then causing a person's death. Constructive intent, substantial likelihood of an event occurring even if there was no specific intent. So in other words, the actions resulted in the death of the individual. Model Penal Code states federal government, Congress has adopted the MPS, but the Supreme Court, the Congress has not adopted it, but the Supreme Court refers to it. But the MPC rejects the common law definition of intent. Anyway, the key thing is that you were culpable, you were involved. And how does culpability come about? By intentionally, knowingly, recklessly, and criminal negligence. You'll see a lot of this in the statutes themselves. Intentionally, knowingly, recklessly, with intent, and those kinds of things, you'll see that. Missed aim, transferred intent, where a person shoots at someone, for example, and hits an innocent person. That's transferred intent. Applies to arson, where the intent was to create a fire, but you end up killing people. And most of these cases that they say involve homicide, where a third party was injured or killed. Strict liability offenses, I'm not going to spend time on it because we already talked about that enough. But if you need more details, excuse me, feel free to go through these specific ones. We're running out of time, so I want to finish. So we already talked about strict liability. Okay. Strict liability offenses. Causation means that there exists a link between cause and effect. The gunshot, for example, caused the death of a person. That's the cause of the death was the gunshot. If the gunshot didn't exist, or but for, as we say, then the person might not have been dead. Or is also called proximate cause, a cause that is a natural continuous sequence unbroken by intervening causes and produces the consequences. If there is an intervening cause, punishment will likely be different for the offender. Let me give you an example here. Okay, here we go. This is an example, so you get the point. Emma is raped and left to die in an uninhabited area by John. Emma manages to crawl to the next street, and a truck driver picks her up and intends to drive her to the next hospital. But the truck driver causes an accident in which Emma dies. And so the question is, who caused Emma's death? Was it John or the truck driver? Some might say if John had done what he had not done that, then she never would have been in the truck. But the question is, should John and the truck driver be charged? The question is, it depends on the truck driver's issue in terms of causing her death. Was he negligent? Did he do something wrong? But here's the point. John is not involved at all because of the fact, remember I talked about an intervening factor. And the intervening factor was he raped her, but he didn't kill her, but he would be charged with a different crime than her death. That's the point in showing how causation works. It makes sense when you stop and think about it. Now we have this thing that we call felony murder. Felony murder says if you're in the process of committing a felony and someone dies as a result of that, that you are held responsible for their death. So, for example, they use an example in one of our scenarios in this class that a person fires shots at a person playing basketball. The person playing basketball fired a shot back. And instead of hitting that person, the partner of the person died. And so the person who initiated the action is charged with the murder of that person, even though they didn't fire the shot under the felony murder rule. Because if they had not fired the shot, the people on the court wouldn't have fired back. That's how that works. So I think that makes sense to everybody. If you have any other questions about that, you can feel free to reach out to me, and I will be able to elaborate on it. But I think that's pretty clear there. Parties to a crime, the principals, those who are directly, there are different degrees. Principal in the second degree was not directly involved, but was someone who helped or aided and abetted. Then there's an accomplice, person who gives aid and comfort to the principals themselves, might conceal them, hide them, those kinds of things. We're almost done, actually. Accessories before the fact, one who procured or counseled another to commit the felony, person who was not actually present at the commission, but accessories after the fact, one with the knowledge of the other's guilt rendered assistance to a felon in an effort to hinder the felon's arrest or punishment, like I was talking about hiding it. But accessory before the fact, like providing a gun to somebody and then they go and kill somebody, you are an accessory before the fact, even though you weren't there. Both substantial and procedural distinctions between principals and accessories have pretty much gone away. And the modern law pretty much says all persons concerned in the commission. So that includes both, whether it be a felony or misdemeanor, and whether they directly commit the act constituting the offense or aid and abet in this commission, or not being present. So it's a catch-all. So that's pretty much the way many statutes are written now. But accessories after the fact still exist. Some states exempt spouses and other classes of relatives. See, I told you, right at 10 o'clock. We did it. So let's go back to class. Um, any questions? Any questions from either of you? Concerns? I do want to again remind you that when you complete your assignments, please run your papers through Grammarly. Make sure that as you run them through Grammarly that you check to make sure that you're giving more critical thinking, and we already discussed that in the open house in detail. And make sure that you have your APA citations in the body and references at the end. We provide you with many resources in the class to help you with that. So it's about 10:01, right on time here. Um, we have completed it. Next week, you will be covering chapters 5 and 6. I will be sending you at the beginning of the week the PowerPoints and the outlines about it. But you have plenty of information to help you complete your assignments and understand the module. And again, take your time, do a good job. And remember, this week you have no project. You just have the written assignment, and then you have your discussion post and the quiz. Of course, do your reading and use the PowerPoints that I submitted to you. So with that, I'm going to say good night to each of you. Thank you for coming out. I will see you in week 4 with our next lecture. And as usual, you know how to reach out to me if you have any questions. Some of you I've talked to already. I always love talking to my students, and I have extensive discussions. And I like to help my students as well. And so with that, I'm going to say good night and terminate this meeting.